All right, this is segment part 6 of week 2 of my SIUE class, CJS, Criminal Procedure. And we had talked a little bit about the First Amendment, but the main thrust of the First Amendment is the government cannot stop free expression. There are many exceptions to this, and I gave a lecture to lawyers for their continuing legal education that will be posted here or is already on the blackboard that you can see, which is part of the course material. I'm not going to use it right now, but what it means is if you want to have purple hair, the government cannot stop you. If you want to kneel in an NFL game and you're an NFL player, there's no governmental entity on earth that can punish you, charge you with a crime, or stop you from kneeling to show your views on your political views, your views about police. That is all lawful. So free expression is the big takeaway from the First Amendment, and there is nothing like it. These attempts to censor people or to silence opposing views are wrong, and people who want to do that are wrong to the depths of their soul. The way to deal with competing ideas is to have more speech, not less, to show why your political opponent is wrong about facts or about an opinion or about a policy. That's how civilized people deal with it. We don't deal with it by burning books. I saw Bibles being burnt in either Portland or Seattle. And I'm agnostic. I don't have a religion because I don't know what the truth is. But I'll tell you what, I hate seeing any books burned in the United States because that is exactly what the Nazi Party did in Germany from 1933 to 1945 with disastrous consequences for millions of people in Europe, millions of people around the globe, and for the German people themselves. Let's talk next about the Second Amendment, and this is controversial because how the founders worded it. It does not say, the right of the people to keep and bear arms shall not be infringed. If it had just said that, there would not have been a controversy for 200 years as to the meaning of this amendment and whether or not it grants individual rights to own a gun. It's because of the first clause that was discussed in the Heller case, Heller versus Washington, D.C., decided by a majority, Justice Scalia, with 4 dissenting justices that emphasized this clause of the Second Amendment. And they were not making this up. The first clause says, quote, a well-regulated militia being necessary to the security of a free state, comma, the right of the people to keep and bear arms shall not be infringed. Let me explain to you why this amendment is inartfully written. If it had said something differently, and I'm going to paraphrase this, if it said, which it doesn't, a well-regulated militia being necessary to the security of a free state, the right of the militia to keep and bear arms shall not be infringed. It does not say that. If it had, that would not give anybody an individual right to own a gun. The government could bar guns, ammunition, you wouldn't have FOID cards, and only people who are in the National Guard, which is the modern equivalent of the militia, would have a right to guns. So they have this middle ground to where it is not written well, but you do see the argument of the 4 justices on the left when they disagreed with Scalia's finding that this amendment does give people the right to have a handgun in the home for self-protection because they cited the first clause, quote, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. They were saying you cannot ignore the first clause and just focus on the second clause. Now, the Scalia opinion and all the opinions in that case from 2008, if you're interested in the law of gun rights, you can just Google Supreme Court decision, 2008, Heller versus Washington, D.C., and the opinion will come up. It's very long, and you see the justifications for both sides, all well written, as to their positions, but the majority did hold. If there is a change to where there's 11 justices or 13 justices on the Supreme Court, it's got to be an odd number, you could see the Heller case reversed to where the views of the minority, the 4 dissenting justices, a dissent is when the justice is not in the majority and they disagree with the majority opinion. They want to state why. That's called a dissent. You could see that definitely change. Let's talk about the Third Amendment. More relevant now than maybe ever before, and it says this, no soldier shall, in time of peace, be quartered in any house, meaning live in any house, without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. So here's what this is saying. If we have a war in the United States, like there was a civil war 1861 to 1865. Every person who has, every educated person should know those dates. That would be a time of war in the United States to where an army could be quartered in a house in a manner as prescribed by Congress for the Union. So let me read this again. Amendment 3 says, no soldier shall in time of peace be quartered in any house without the owner's consent. That's pretty straightforward. But in times of war, they can be quartered in your house in a manner as required by law. That's pretty interesting, isn't it? The main focus of our time in this CJS 207 class is going to be search and seizure law, and the source of that is in the Fourth Amendment, and there are two very important clauses to the Fourth Amendment. It is short. It's only about 8 or 9 lines long. Here it is. I'm going to read it to you, and we'll talk about the clauses in a minute. Quote, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. And, second clause, no warrants shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Very simple, but there are thousands and thousands of court opinions interpreting the language of this amendment. And I'm not going to break down every word of it, but I do want you to know at this point that there are 2 clauses. And the right to be secure in your person or house had great importance in Roe versus Wade in developing a constitutionally recognized right to privacy where women can control their own autonomy and their own bodies. Let's talk about the Fifth Amendment, which is very big in this class too. It says, no person shall be held to answer for a capital or infamous crime, that means a serious crime, except upon presentment or indictment of a grand jury. Let me explain what that is. This says for major felony in federal court or death penalty case, a grand jury of normally 23 citizens finding probable cause to charge. You have to be charged by a grand jury in federal court if it's a capital or otherwise infamous crime like treason. Otherwise, you can be charged by what's called in federal court, and this is not in here, but it's how it's been interpreted. You can be charged with a drug offense in federal court, drug trafficking, conspiracy to distribute marijuana, by criminal information, which is just the United States Attorney or Justice Department charging you with a document. You have to show up or make bond and you have a hearing. So, the second part of the Fifth Amendment says, nor shall any person be subject for the same offense to but twice put in jeopardy. What that means is if you've been acquitted in federal court, or now interpreted to be state court, of the crime of murdering Joe Smith, and you're found not guilty, you can never be tried again for the murder of Joe Smith. Nor shall a person be compelled in any criminal case to be a witness against himself. This means that you cannot be required to give oral testimony to a police officer against yourself that incriminates you, or you can never be called. There's a prohibition against you being called in court by the prosecution in your case. Now, the way this clause was originally interpreted, 1791 on, was the only Fifth Amendment right you really had was not to have to testify in your criminal case. This, at the time, did not bar the police for trying to make you give testimony or tell your account of the crime. But you may think, and I've seen on Twitter incredibly lately, lawyers say that if you take the Fifth Amendment, it means you're automatically guilty. Well, that is just plain wrong. And let me give you an example. This happened in a real case 7 or 8 years ago in Millstadt, St. Clair County, which is a rural area, to where a homeowner in the middle of the night heard an intruder in the house, a burglar in the house. They got their gun, I think it was a shotgun. The intruder ran out and the homeowner shot the person in the back, killing them. Well, this person was never charged by the state's attorney's office because I'm sure they believed that they thought that a jury of 12 would never convict this person of murder or reckless homicide or any kind of homicide offense because of the nature of the case. I'm telling you that person could have been charged. But what I'm also telling you is that, let's say the prosecutor says, like they did in that case, we're not going to charge, we believe there's reasonable doubt there as to guilt. That would mean that if you have to use force to defend yourself under any circumstances, and that might be a claim that you don't want to make to the police at that time, you have the right not to talk to them. Talk to your lawyer, maybe go to the police with your lawyer. If the lawyer thinks it's in your interest to go to a grand jury or talk to the police about your self-defense. But here's what the privilege means for innocent people. It means that under the facts of the case, the driveway case I told you, which was a real case, the person could have been indicted, and then the first time the prosecution hears their story is at their trial. And let me tell you, as a prosecutor who had many trials during 24 years, the thing we fear most is things we don't know. And I've had murder cases in which a defendant testified and we had no idea what they're going to say. And that puts the government, the state, that does have the burden of proof, of proving guilt beyond a reasonable doubt, at a big disadvantage, because the defendant knows what he's going to say, the defense lawyer knows what she's going to hear, but the state has no idea. And that is an advantage that the founders gave to the accused. So we do not have an inquisitorial system of justice where we assume or presume guilt. That is illegal at almost all levels of the civil justice system too. We have a part of the prosecutorial system where the state has the burden of proof, and they have to use admissible evidence to prove your guilt, 90 to 100% certainty. Not absolute certainty, but with real evidence that is not subject to much dispute. That's what proof beyond a reasonable doubt is. So let's go back to the Fifth Amendment and the other parts of it. Nor shall the person, meaning the citizen, be deprived of life, liberty, or property without due process of law. This is the Fifth Amendment due process clause, first time in the Constitution, first time in history, that says the federal government cannot take your life in a capital case without giving you due process, cannot take your freedom, cannot even take your property without due process. We talked in the first week about what due process is. Due process is very easy to understand. It is that process which is due you in a court of law, according to law, before you can be thrown in a cage or before you're put on probation. You have certain rights, and the rights are procedural rights. You remember what I told you the first night? In general, a fair process, in my view, guarantees a fair result. In other words, normally jurors are always right, in my experience. If they find reasonable doubt or if they convict, they're probably right. I think jurors really do take their job seriously and want to do a good job in an unbiased manner. So you cannot be deprived of your freedom, liberty, or property by the feds without due process of law. That's what part of the Fifth Amendment says. The last part says, in the Fifth Amendment, nor shall private property be taken for public use without just compensation. Here's what that means. If you own a farm in rural Illinois and the government at all levels wants to take your farm in order to build a highway on it, there is a trial, literally, there is a trial to determine how much money you're owed or what is the fair value of that land. That's what that clause means. How are we doing on time, Mr. Allen?
I have 7 minutes left.
Thank you. Sixth Amendment looms large in this class and is really the right to counsel. It says, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district where the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, meaning accusation against him or her. You have a right to be confronted with the witnesses against him, to have compulsory process, subpoena power, for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. So let's break this down a little bit. This only deals with criminal prosecutions. I've been asked for years in civil cases, do you have a right to the public defender? Do you have a right to a free lawyer? And the answer is, there is no constitutional right to that. You can represent yourself. People who are indigent, which tend to need lawyers the most, frankly, can, in this county, go to Land of Lincoln Legal Assistance down the street from my office in East St. Louis to seek to have a custody lawyer, divorce lawyer, or free lawyer, because we know that many people who need lawyers cannot afford it, and is a real tragedy. So first of all, the accused has the right to a speedy trial and a trial in public by an impartial jury where the crime allegedly happened. And you have a right to be informed of the nature and cause of the accusation against you. You have a right to have written notice of the charges against you. You have the right to be confronted, in this case, the state's case against you, with the witnesses against you. In other words, you have a right to cross-examine them. And that means to test the veracity of the witness through time-honored ways. God, I've had some great training in cross-examination. I went to a seminar, prosecutor school, for a week in the year 2000 at Northwestern School of Law. And Terry McCarthy was the public defender for the Northern District of Illinois, a wonderful man. I think he's gone now. And he taught both defense lawyers and prosecutors at his all-afternoon seminar on how to cross-examine a witness effectively. And it was really the best education I could have ever had. Also, you have a right to compulsory process. That means subpoena power to get witnesses in your favor to court. Here's what happens if they don't show up. The judge is supposed to have the sheriff go out with a warrant to have the person who was validly served with the subpoena to be there in court show up. If the person is picked up and taken to testify, normally after the testimony ends, there won't be any charge against the witness. I would not be in favor of that in most cases. However, they could be charged with criminal or civil contempt of court, which means defying a court order. A subpoena is a court order to testify, and they can be thrown in a cage for that. Also, you have the right to a lawyer. Now, this does not say you have the right to a free lawyer at the time. At the time, in 1791, it just meant that if you have the wherewithal to have a lawyer, or a lawyer who will volunteer for you, that lawyer must be recognized by the court. Now, of course, with the Gideon versus Wainwright case from 1963 that was filed for by a pro se defendant who was a prisoner, Mr. Gideon, where he filed a brief in the Supreme Court asking him to take his case, and sure enough, 4 justices took his case, and he won the case, which establishes for all time, and you will have to know this case name, Gideon versus Wainwright, that people in felony cases all over the U.S. have a right to a free lawyer, even if the state does not want to put you in a cage, if they're just going to seek probation. If you're charged with a felony, free lawyer. It's like an equation. How are we doing on time, sir?
3 minutes left.
Okay, thank you. Seventh Amendment, I'm going to paraphrase it only. It deals with civil rights cases. It also deals with any federal civil case, which means a case over money. It says that you have a right to a jury trial in a civil case in federal court. The Eighth Amendment, there's been a big Eighth Amendment case issued by the Supreme Court in the last year and a half. Justice Gorsuch from Colorado wrote the majority opinion. I think it was unanimous. And here's what the Eighth Amendment says. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. So the issue always becomes, when we talk about the Bill of Rights, which of these Bill of Rights that is on the surface is only applying to the federal government also applies to the states. Well, finally, in the year 2019, Justice Gorsuch and the Supreme Court decided that the federal prohibition in the Eighth Amendment against excessive fines does apply to the states. And they applied that, I think, to Indiana over a seizure of a vehicle that was vastly in excess. The value of the car was vastly in excess of the dope that was obtained in a search. But the excessive bail part has never been held by the Supreme Court. It's the only one of the Bill of Rights that does not apply to the states. Hopefully that will be changed, because that should be a federal civil right against state government, state courts, state judges. People should not be held in bail excessively, especially for nonviolent crimes. Okay, we're going to stop now, and the next time we talk, we'll talk about the 9th, 10th, 11th Amendment and the Civil War Constitutional 3 Amendments. Thank you very much.